It says we're live. Are we actually live? Is this thing actually working? I'm really hoping that my audio is going to cooperate. It always looks like it's fine on my end. So, before we go too far, hello, hello. Let's do a mic check. Echoes, if you're still in here, honey, how bad is it? Thanks for being here. How are you? Welcome on in. So, hopefully, I'll be able to read through this doc. I just don't want to go too far if my audio is really bad. Meg P, hello, beautiful. How are you? You sure echoes? It's not like clipping out or anything? Sound is good, tattoo gal? Tattoo gal. Hello. Interesting. So my sound is good right now, huh? Meg P. Oh my gosh, stop it. I'm hiding in a fort at a birthday party during a Nerf war. That's awesome. I want to be at a Nerf war, actually. That sounds like a lot of fun. All right, so sound is good so far. Okay, awesome, awesome. I guess I'll give it a minute, let some notifications click in. I know Lana's live. I'd scheduled this earlier, for like 9 o'clock, hoping that after I did a few things and, um, I had some things to do on the computer. I played fiddly fuck over here for a little while. And hopefully I've got it figured out a little, um, enough to at least be able to read through the docs. You know, Batsheet, hello, welcome on in. So yeah, I mean, I truly, truly do appreciate it. I would rather you guys tell me when my audio is absolute shit, you know what I mean? So that at least I know and I can pause or whatever. If I need to end it, I'll end it because I just don't want people coming to watch the video or the live and the audio's bad and no one's telling me. Do you know what I'm saying? I don't want the video like getting recommended to people or people clicking on it to watch it. And they're like, this fucking audio is terrible. I mean, shit, that's normal around here, right? If you're new here and you don't know, um, myself and audio issues, we're like a bonded pair, right? So for anyone who's new here, yeah, audio issues are a thing. The audio on this channel is the real MVP. Okay, it's the real MVP. Um, and it's not that I have shitty equipment, and it's not that I'm on Wi-Fi or anything like that. None of those things. I was actually on the phone yesterday with the internet company for like 2 hours. They tested everything. Everything's fine. They're sending someone here Monday to check the actual pole and the lines on the pole. Because it's not my internet and it's not my modem. It's none of that. They checked it all. So, yes, yes, echoes. You will probably get a lot of F words today. Anna D, hello, honey. Welcome on in. We're trying this again. So thanks everybody for being here. Appreciate all of you. Yes, leave a like, just like leave that thumbs up, just like Brian Kohberger. Give it a thumbs up, just like Kohberger. Too soon. Too soon, Meg. Might be too soon. Ray, how are you? Wait, I think I asked you this before. It's Ray, right? That's how you pronounce it, Ray. How are you? Bringing the hot mess express. You fucking know it, bro. Especially with the audio. Nothing but a hot mess express over here with the audio. I could literally go spend $1,000 tomorrow on all new shit. And I promise you, we are still going to have a problem. So it is what it is. You know, it is what it is. But yeah, hopefully we'll be able to do this and it's not going to be too bad. Um, I know that, yes, there are some newly unsealed docs. I did go through them. Um, I mean, there's a couple of them that I'm like, oh, okay. Um, but you guys all know the one I was really waiting on was the alt perp stuff. I mean, it's no secret. I think that's the one we've all kind of been waiting on. Spoiler alert. Spoiler alert. The four alternate perpetrators are males, and they were the state's own witnesses. So that's super, super, super interesting. And another thing that I found to be super, super interesting as well, of course, she hears me talking and it's not to her, so she's up there meowing. Um, Another thing that I was trying to point out today in my earlier live that was absolutely terrible um, was that I was trying to read the 25-page affidavit from the state's DNA expert who handled item 13.1. Nelly, what's the problem? Hang on one second, friend. So sorry, I gotta mute for 1 second. Liza, or Lisa, however you pronounce it. Hello, welcome on in. Good to see you. Yes, we're all in the pothole, that's right. Everyone in the pothole halls. Hi, honey. How are you? Welcome on in. So, as I was reading this man's 25-page affidavit, something that stuck out to me was second version, Lisa. Okay, you got it, Lisa. Welcome on in, Lisa. Hang on, let me go check on my cat. I'm pretty sure it's a bug. She probably sees a bug. I'll be right back. 1 second. It wasn't a bug. She just hears me talking and it's not to her. Okay, so 25-page affidavit, state's DNA expert, talking about item 13.1, the fingernail clippings from Madison Mogan. Probably the one thing that stood out to me the most out of his entire 25 pages is that, in his words, this is his words, he's a professor, he's a teacher, you name it. His CV is there if you want to go read it. The guy's background is insane with what he teaches for DNA. I believe he's taught in Denmark and Amsterdam, in the UK. He helped the UK a lot with their DNA stuff. Um, but anyways, probably the thing that stood out the most to me in his affidavit was that he said the higher the likelihood ratio, the stronger the evidence, right? So, like, out of all 25 pages, that one sentence stood out to me so much because of everything that went on with Jade Miller and the likelihood ratios that were created, right? So, according to this DNA expert, it's best practice. And this is like standard across the field of forensics when it comes to DNA. If you are creating likelihood ratios off of profiles obtained from pieces of evidence like a victim, right? And when you're creating these likelihood ratios, the higher the likelihood ratio, the stronger the evidence. That is super interesting to me because Brian's was the lowest and excluded, right? So out of all of the likelihood ratios that Miss Miller for the ISP lab is generating and creating based off the swab from the fingernail clippings, according to this DNA expert for the state, the higher the likelihood ratio, the stronger the evidence. And that is just so crazy to me because that would mean that your evidence, your likelihood ratio, the highest one, that is your strongest piece of evidence that you should be pursuing and you should be going in that direction, and you don't, right? It's super, super interesting to me. The higher the likelihood ratio, the stronger the evidence. And out of all the likelihood ratios created for the males, Kohberger, Brian Kohberger, I forget the other one on there, and Ethan. Okay? Ethan had the highest. It's just a fact. It's just a statistical fact based on the likelihood ratios that the ISP lab created. The numbers that they generated, Ethan had the highest likelihood ratio of 3.33. Everybody else was a 0.0 whatever. So, I know that my audio was absolutely terrible in the earlier live when I was trying to read that document, but out of his entire 25-page affidavit, that was the sentence that stood out the most to me. The higher the likelihood ratio, the stronger the evidence. So that's really interesting to me that, because it just begs the question, then my brain says, okay, so they had, if they know that it's best practice across forensic science itself, that these labs, when they're creating these likelihood ratios, there's a standard protocol that you're going to follow to create that likelihood ratio. And furthermore, the higher the likelihood ratio, the stronger the evidence. So, how come you didn't pursue your highest likelihood ratio as your strongest piece of evidence for that particular evidentiary sample, right? Ray, I have no idea, honey. I literally could not tell you. I don't know, darling. Maybe one of the mods knows, but I truly have no idea. Do I have to be on desktop to become a member, or is there a way on the mobile app? I literally have no idea. I just know that like from your phone, like when I'm on my phone, I can give memberships and like do super chats and stuff where the little money symbol icon is in the chat, but like outside of that, I have no idea how you would join, darling. I really don't. I have no idea. Um, hmm, I'm not exactly sure. But thank you for wanting to join. I appreciate you so much. RJ, you couldn't figure it out either. Yeah, I'm not sure. I really don't know. Maybe one of the mods knows, but I really have no idea. Bree Sully. What up, gangsta? Hi, Bree. Hi, Bree. Anna D, you get what I'm saying, right? Tattoo girl, profound, yeah. I mean, uh, Michelle, hello, darling. Yeah, Meg, keep us updated. While you're hiding out in that fort during a Nerf war, please keep us updated as to who's winning. Bunny Murphy, hello. If you have an iPhone, pretty much. Oh, okay. Yeah, could be tattoo gal. I'm not sure. Look, I'm not sure what's going on here, okay? I'm never gonna ever try to pretend to people that I know for a fact what's going on here because I truly don't. All I know is that Brian Kohberger, right, has pled guilty to this crime and claims that everything the state alleges is true. And the state is alleging he was alone, did this in like a minute and a half, had time to clean up after himself, and not leave a trace of evidence in his vehicle. And he agrees that's true. So, for me, that just tells me Brian's a fucking liar. Okay? That's just how I take it, friends. If you want my honest opinion, that means that Mr. Kohberger is lying. Okay? Because we all know right? I think we can all agree he likely is not Jason Bourne, John Wick, Michael Myers, and a ninja all rolled into one. He can't be on 3 floors of the home at the same time. He can't be lighting off fireworks on the first floor if he never went to the first floor. Know what I mean? So, it's just my very strong opinion that for whatever reason that he felt he needed to take this guilty plea rather than have it go to trial, okay? I don't know what that reason is. What I do know is that he can't teleport. His vehicle can't teleport. He can't be on 3 floors of a home at the same time. He can't be lighting off fireworks on the first floor while also stabbing people on the second and third. It's just, so I'm sorry. Great. I'll take his word for it. He says he was there. Awesome. Great. My mind can go there. No problem. I'm very open-minded. Who were you with, asshole? Right? That's just where my brain is at. Okay. You say it's you, so who were you with? Right? Who were you with? That's just how I look at it. Because they've always known, in my opinion, this is just my opinion, don't listen to me. I don't know shit. There are no facts here. Disclaimer in case I, haven't said it already. Don't listen to me. Read the docs yourself. Come to your own conclusion. I'm just some snarky bitch on the internet who has an opinion about what I read, and that's it. Okay? But it is my very strong opinion that they've always known he wasn't alone. There's more than one weapon. This is why Gilbertson won't talk about the second weapon, even though he knows it wasn't a fist and he knows it wasn't a knife. It's because in my opinion, Gilbertson knows what the second weapon is. They know what the second weapon is. And it's not Kohberger's. It's not Kohberger's weapon. That's why they don't want to talk about it. They've always known there's more than one perp. And as we'll read in this defense filing that's been unsealed regarding the alternate perpetrators, that's something that's stated in this document, that the state has conceded. They have always been aware regarding the, multiple perp thing here. So it's pretty interesting when you really think about it. If he wants to say he was there, okay, great. Awesome, Brian. You were there. Cool. Where are the weapons? Who were you with? And what car were you in? Right? Because obviously he wasn't in his car. Right? He seems to know he wasn't in his car. His defense team seems to know he wasn't in his car. The forensics didn't detect anything in his car. So if you were there, whose car were you in? Right? He's saying he was there. Did he go leave his car at the park and get picked up by someone there? I'm just saying. Because, as much as everybody likes to say, like, Cy-Ray, 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 like, Cy-Ray also can't prove Brian's location during the time of the murders via Brian's phone. As far as I know, that's not what Cy was testifying to, right? Cy was just going to be testifying to the fact that they had some of their times off, the drive test data was all fucked up, their machine was malfunctioning, it's either the machine or the operator, or both, right? So Ray knows he can't actually prove Brian's physical body location via his device, just like the state can't, right? If the state can't prove Brian's location via his device, obviously Cy wouldn't be able to do that either. Know what I mean? So, I mean, I'm just of the opinion that, I don't think that Cy Ray is going to come out and all of a sudden just have this, like, bombshell, like, nope, I know exactly where he was. He was nowhere near the house, and etc. I don't think he's going to be able to say that because at the time that the phone either is disconnected, turned off, stops connecting, whatever's happening there, you at that point can't prove his physical location for the time that his device is either off or not communicating, right? Um, unless there's some other backdoor data that, they used, or that Psy may have been able to show that, like, nope, the phone wasn't actually turned off. It was on. It was just because he was, here in this mountain range, right? Is why, there could always be something like that. But I'm just of the very strong opinion here that whatever happened in the last like month and a half leading up to this, his defense team allegedly approaching the state for a plea, whatever happened here, he felt it was in his best interest to just take the plea instead of going to trial. So, and he says he was there, and he says everything the state alleges is true, right? So, I just look at it as if what he's saying is true, and he says he was there. I mean, at some point we have to ask the question, okay, well, if you were there, then who are you with? Whose car were you in? Where are the weapons? Right? Like, let's stop playing fiddly fuck here. Okay? Like, I get it. There's a lot of people who think Brian is 1,000,000% innocent, even after him taking a plea, and that's totally fine. We are all entitled to our own opinions. But it, you know, yeah, exactly, Ray. He's Voldemort. Um, it, here's how I look at it, okay? I'm looking at it from, let's play devil's advocate for a minute, okay? And if he is saying that, yep, it was me, everything the state alleges is true, it was just me, okay, cool. So if that's true, why on earth would the state prosecutor ever, even if this defendant and his team are approaching you, asking you, hey, is there any deal you'd be willing to offer? Why are you ever saying yes? Right? Why would you ever? Bill Thompson, state prosecutor, Jeff Nye, the whole team, Jennings. Why would any of them ever entertain offering this fucking monster, okay? This monster a plea? Why would you ever do that? Right? Because I'm looking at it from the angle of how weak of a fucking prosecutor are you? That if you know he did this, he is now saying he did. What kind of yellow belly bitch are you that you would even entertain giving someone like that a plea? No, the answer should be absolutely not, Brian. We're not gonna fucking offer you a plea. Fuck no. We're going to show the whole world you did this so that they all are behind us executing you and sentencing you to death. Do you understand where I'm coming from here? Like, put on the hat of prosecutor. If you are the prosecutor in this case and you know this person did this, even if there was somebody else with him, even if he had another person with him, maybe there was another perp, maybe that perp is also, maybe that perp is dead. I have no idea, right? But if you know he definitely fucking did this, and you have the evidence to prove that shit, okay? I don't understand as a prosecutor how you'd ever entertain a plea, even if they ask for one. I would never. I would tell him to absolutely piss off into the sun, him and his defense team. There will be no pleas here. We attach the death penalty and we fucking mean it. Right? I'm just saying. This whole shit of prosecutors attaching the death penalty for the purposes of leveraging a plea is bullshit, and it needs to stop, and that's just my opinion, and that's all that Bill does. He attaches the death penalty for the purposes of leveraging plea deals. And I'll give it to Brian and his team. They tried to hold out to the last minute, but I got to tell you, there isn't a single thing they could say to me or do to me that's going to make me say or plead guilty to killing 4 people that I know damn well I didn't touch. I don't know them. I was never in their home. I was never at their house. Know what I mean? Lana's working on Sheldon's case right now. Sheldon will not take a plea. Sheldon has been in jail for years fighting his case. And no matter how many times they offer him a plea, he will not fucking take it. Because he says, I did not do this. And I am not going to fucking plead guilty to something I didn't do. So, I mean, I don't know, guys. I'm just trying to look at it from all angles, and I have no problem playing devil's advocate here. And if I'm the state, I gotta know why, if you're the state, you would ever offer anyone, Kohberger or otherwise, the people who did this, why you'd ever entertain a plea. To me, it just seems so absolutely, it's diabolical. And then to tell the families as the prosecutor, hey, if you want, well, only one family in particular. Prosecutor tells one family in particular, if you want any information regarding this case, you'll have to FOIA it like everyone else, knowing damn well that 2 other families were about to slap down fucking emergency restraining orders on the FOIAs and on the public records requests. Do you know how diabolical and demented and sick in the brain you need to be to tell the Gonzalez family that the only way they can get information about this case is via a public records request, just like the rest of us, knowing damn well there's about to be fucking a temporary restraining order coming? You think Bill didn't know that those families were going to file that restraining order? Of course he did. And this sick, evil bastard had the nerve to tell Kaylee's parents, well, if you want that information, you'll have to FOIA it like everybody else, knowing damn well the FOIA, sorry, all that shit's going to be put on hold, and if you get anything, it's going to be heavily redacted because, well, temporary restraining order till the judge makes a decision. It's fucking demented and diabolical. I don't care what anybody says, right? If you're going to attach the death penalty, you better have plans to follow through with it. It should be when they attach the death penalty to a case, the court requires them to follow through on it. They already have a higher burden that they have to meet, right? There's a higher burden of proof. There's a higher standard already for that when you attach the DP. So, in my opinion, it should be mandated that if you as a prosecutor want to attach the death penalty to your case, there will be no plea deals once you do that. You will not be able to offer a plea, even if one is asked for. Know what I mean? That's just my opinion, though. What do I know? But I do think it's bullshit that one of these families is being told the only way they can get information regarding their daughter's death is via a fucking FOIA, like the rest of us, knowing damn well those FOIAs are kind of on hold, and if they aren't on hold and things are being released, they're heavily redacted, and you're only getting portions of it. So, yeah, pretty fucking sad, in my opinion. So, I mean, I don't know what to say, guys. It's just my honest opinion on how I feel. I'm not going to sit here and continue to try and pretend that, like, oh no, like, Brian, did you go there with the intent to commit murder? Yes. What am I supposed to say to that? Other than, if he didn't actually stab anybody, I don't know, was burglary the motive? What was he there with someone else and, burglary was the actual motive? And, shit went sideways? I have no idea. What I do know is he's saying he was there. He's saying it's him. He's saying that it's what the state says is true. So, what the fuck am I supposed to say to that? Other than, okay, cool, Brian. You say it was you. Now you need to talk about who you were with and what you guys did with the weapons and the clothes you were wearing. Right? Just my opinion. Andrew, welcome on in. Audio's good? Well, thank goodness, right? I crossed all my fingers and toes before I came in to the live tonight. I crossed fingers and toes and said a prayer to the tech gods. Simply Solo, what up? Welcome on in. I know, right, Ray? It is super fucked up. The family should get whatever they ask for. I agree. Yeah, yep. The family should just get the whole discovery. Why not? But nope. If they want it, only the G's apparently. Only the G's are the ones who need to file a FOIA for information on the case. I'm not sure how true that is, but allegedly, according to them, that's, what they were told. So, that's pretty interesting. Um, he's saying whatever it takes to take the plea. Who is? Brian, you mean? To know? They live. Hello. What up? Sorry, I'm lagging a little bit. Is my audio clipping in and out as well? I noticed that, like, I'm lagging a little bit, even though I shouldn't be. Hopefully my audio is not clipping out. Let's do this before it goes insane. Yeah. But I mean, if he's saying whatever it takes to take the plea, I don't know what that means, though. Audio's good. Thanks, Batsheet. I don't know what that means, though. Saying whatever it takes to take the plea. But why would he even ask for one if he didn't do it? Why would Brian Kohberger or his defense team ever advise him to seek a plea deal from the state if they know and he knows he had absolutely nothing to do with this and was never near this home or with anyone who was near the home? Know what I mean? Well, I understand innocent people take guilty pleas, right? And it's usually the state approaching them, not the other way around. The defense has never once said that what the state asserts about them approaching the state about a deal is not true. The defense has never said that's not true. So if it's true that Brian and his defense team approached the state but they know he had absolutely nothing to do with it, that's super weird. It's super strange. I understand that the state had been offering plea deal. I understand that Hippler, at one of the last hearings, said it's your last chance. Any last deals, you need to do them now. And then, according to Bill, Anne is the one who called the state asking about a plea and any deal they'd be willing to offer. I mean, I don't know why they do that. I really don't. Other than Anne had already made the court aware. She asked for a motion to continue, claiming she was not prepared for trial, and forcing her to go to trial would make her ineffective. It would be ineffective assistance of counsel if she's forced to go to trial and not prepared, right? The judge denied her motion to continue. Therefore, she would have been forced to go to trial unprepared. So maybe that's where, you come into a situation where the defense would approach the state because their motion to continue was denied, motion to introduce alt perp evidence denied, everything was denied. I mean, I guess at that point you're kind of hamstringed, right? Your judge is now going to force you to go to trial even though you will be unprepared and ineffective. Well, what the fuck else do you do, right? Do you go to trial? I would have went to trial, if I can be quite honest with you. I would have went to trial and I would have got it all documented on the record and preserved the record that the judge is forcing me to be ineffective for my client so that my client can appeal the fuck out of this. No? Wouldn't it make more sense to go to trial so that it's preserved on the record? The court knew you'd be ineffective and forced you anyway to be ineffective. It's fucking automatic appeal. Automatic appeal. They could have absolutely went to trial and been ineffective, and it would have been automatic appeal. So, I mean, like I said, I'm not going to pretend that I know anything because I don't. What I do know is that there's a lot of shit here that just don't make sense. Okay, I understand the body cam interviews are coming out now. I saw the one for Bethany. Um, you know, it's just it's none of it's making sense. I'm sorry. I'm sorry. It's just not. It actually makes less sense. That's, and I didn't even know that would be possible. I never in a million years thought it would actually be possible that it made less sense the more that things come out. But somehow it does. Somehow it just makes less sense. So, let's get into this. I appreciate every single one of you for being here. Thank you. Welcome in, everybody. Mods, I don't even think I have mods here right now. So, mods, if you are here, welcome people in when they come in, if you don't mind. When I'm in another window reading, I can't see my chat friends. So, I'm going to share this with you, and we'll get to reading. All right, everybody cross your fingers and toes and say a prayer to the tech gods that the audio holds up for this bullshit. Okay. Make this bigger. Let's make sure I'm out of the way here. Yeah, see, it says I'm sharing. There we go. I do have a little bit of a lag, I'm noticing. Sorry about that, guys. Oh, my mods have been working. Thank you, mods. My mods are in WITSEC. Yeah, they are. They're in Lucy's basement. Lucy's got all my mods in her basement. Well, actually, Meg P is hiding out in a fort right now. In a Nerf war. So hopefully she's kicking ass in the Nerf war. That much I do know. Hopefully you're kicking ass in that Nerf war, Meg. We love you, darling. Give us updates. All right, so let's get back over here. Okay. All right. So, this was filed by the defense June 13th, 2025. It is the defendant's reply to the state's objection to the defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrators. Comes now Brian C. Kohberger by and through to the defendant's offer of proof regarding alternate perpetrators. I get my highlighter. And defendant's evidence in support of offer of proof of alternate perpetrator, filed on June 6, 2025. Whether rooted directly in the Due Process Clause of the 14th Amendment or in the Compulsory Process or Confrontation Clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Crane v. Kentucky. The error excluding such evidence is reviewed de novo on appeal. Due process rules trump evidentiary rules. Okay? Let that marinate. Rules always trump evidentiary rules. U.S. v. Lopez Alvarez. How long has Ann Taylor said, I am arguing this as a due process violation over and over again. When reserving its ruling on the state's motion in limine regarding alternative perpetrator evidence, the court stated, quote, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime, end quote. Okay, so it can be direct or circumstantial. Okay, you know, like the circumstantial case that they built against Kohberger? Right. The defense is also allowed to present circumstantial evidence linking the alternate perpetrators. It doesn't have to be direct evidence. Yeah? Let me come back over to chat. Everybody can see that, right? What that says there? Oh, for fuck's sake, and my chat seems to be gone. Oh, there we are. Hello, everybody. Welcome on in. Welcome on in. Good morning, good afternoon, good evening, whatever time it is where you are. I think I'm lagging and I'm losing my chat. Oh no. P Fox, what up, gangsta? How's my audio holding up? You guys, you gotta let me know if my audio shit, okay? I don't mind it. Please tell me. I would rather you tell me than I sit here wasting everybody's time reading with my fucked up audio. How do you get the damn Michael Myers emojis? Oh, you have to be a member. Somebody will gift you, maybe somebody will gift you a membership. Although everything is falling apart right now, I can see it. I can see it. I can see it happening. There we go. Okay. Audio is the best ever. It's working great. Okay, cool. But I'm lagging big time on my end. It's taking a while when I click on a comment for it to pop up. Audio's good. Okay, cool. Thanks, friends. Appreciate that. But you see that right there, right? In this document here, where it says, when reserving its ruling on the state's motion in limine regarding alternative perpetrator evidence, the court stated, quote, the defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. Clifford S. Kenna Jones on evidence, and then it cites 7th edition, December 2024 update. See the order memorializing oral rulings on the motions in limine, page 6. The state has listed all of these redacted people as trial witnesses. Beep, beep. All of our alt perps are the state's motherfucking witnesses. Beep, beep. Sidebar. Out of all of the state's witness list, just curious, how many exactly of the state's witnesses are male students and or boyfriends or ex-boyfriends? And how many of the state's witnesses are male police officers and or investigators? Just curious. It's just my little sidebar question here. Just questions. I don't know shit. Just questions. Okay. Dallas up in here. Did I just see Dallas up in here? Hello, Dallas. Amy, thank you. Squirrel kisses. Hello. So, isn't that super interesting, huh? I'm just trying to remember. Maybe some of you know in the chat. I'm trying to remember the state's witness list. The state's witness list is all law enforcement, correct? I feel like the only witness maybe the state was going to call that's not a cop was Hunter. Weren't they initially like going to be relying on Hunter Johnson and Emily or something? And then that was also out. Uh, it was only Hunter's who was determined not to be hearsay because he was actually like someone who went into the house and right. So I'm super confused that if the defense is naming four alternative perpetrator suspects, and those four alternate perpetrator suspects are the state's own witnesses. Um, okay, that's pretty wild. Um, hmm, let's continue reading. So the state has listed all of these redacted people as trial witnesses. The state has also disclosed and labeled exhibits that it intends to use at trial, which include the names or actual video of these witnesses. These exhibits include redacted. Each of these alternative perpetrators identified by defendant and listed as witnesses by the state are more closely tied in knowledge, opportunity, and possible motive to the crime than Mr. Kohberger. All four of the alternate perpetrators are linked circumstantially or directly to the crime. Circumstantially or directly to the crime. Moreover, given Mr. Kohberger's expert disclosures that more than one person committed the crimes, other evidence supports the defense theory that Mr. Kohberger is not the person, and the crimes were committed by more than one person. The defendant's offer of proof, in part, arises from the state's motion in limine regarding alternative perpetrator evidence filed February 21st, 2025. I'm going to pause here. Sidebar, bitches, we just went over this. Were y'all here for the last live? Where I didn't even know this was coming, but something in my whole soul said, go take a little peeky poo at the motion in limine from the state regarding alternate perpetrators. We just did a live about this like a week and a half ago and went back and looked at the motion in limine. And when we read through that, what did we learn? Well, we learned that it was unclear when the offer of proof for alternate perpetrator should be made because one court's ruling said it should be made at trial. And in Buck, I believe it was the Buck decision where the offer of proof could be presented to the court first for the court to determine if it's relevant and or admissible. And the reason that that was determined in Buck is because, well, what happened there? The state in that case filed a motion in limine first to keep out alternate perpetrator evidence, asking the court to review it first. So that's what the state also did here in Mr. Kohberger's case. The state filed the motion in limine first for the alternate perpetrators, knowing damn well that they were going to ask that the court have to decide. Hippler decides whether or not it's relevant and or admissible, when in fact, it shouldn't have even been presented until trial. Right? Because under Meister, that's when you'd present your offer of proof for the alternate perpetrators. You'd be able to call alternate perpetrators up onto the stand. You'd be able to cross-examine them. You'd be able to question them. Know what I'm saying? Especially if they're the state's own fucking witnesses. Yeah? Hopefully my chat and my audio is holding up good for everybody. On page 2 of that motion, so the motion in limine from the state regarding alternative perpetrator evidence, so the reason that the defendant's offer of proof in part has even arisen is because the state filed their motion in limine first regarding alternative perpetrator evidence. On page 2 of that motion, the state argued, quote, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. End quote. Sidebar. Where are the supplemental reports for the fucking tips related to Mr. Kohberger prior to his arrest that police followed up on and substantiated? Where are those reports? Because even Miss Massive is getting it. Look at this. I didn't even know this document existed. And I was literally just getting at the same thing in my last live when we reviewed the fucking document, like a week and a half ago. I said, well, where are all the tips? Right? According to the state, literally thousands of tips regarding possible perpetrators were received by law enforcement. And with the exception of the information regarding the defendant, none of those tips were substantiated. Really? Interesting. Where are the supplemental reports for the tips related to Mr. Kohberger? Anyone? Let me come back to chat. Anyone in chat? Lurkers? Haters? I know you're listening. I know you're here. One of you can chime in, right? Which MPD or ISP supplemental report numbers pertain to Brian Kohberger prior to his arrest that law enforcement is receiving tips for Kohberger as a possible perpetrator, and they are following up on those tips and substantiating them? Where are they? Where are the supplemental reports for the tips? Just asking questions. Just asking questions. Oh, well, Ray, look at you, a new member. You look so pretty in green. Thank you, darling. Welcome on in. I'm glad you were able to figure it out. Exactly, Tanel. Right. So if the only valid tip you're getting is from the FBI, right? What do you mean the only the only tips you were receiving that you could substantiate pertain to Mr. Kohberger? When is that, though? Is that after his arrest or prior? When is that? One of the tips for Mr. Kohberger coming in after you arrested him or before? Because I've been through all of these supplemental reports from MPD and ISP, and I'm not seeing a single one that pertains to Mr. Kohberger until after his arrest. So I just want to read the tips that came in, naming him as a suspect prior to his arrest. Know what I mean? He used them to make Horcruxes. Oh my God. P. Fox, we don't even know that answer. You're damn right. Nobody does. I've asked. I had someone try and tell me too that there are supplemental reports related to Kohberger. There are tips for Kohberger. They followed up on them. I'm like, then give me the report number. I'm just asking you for the report number, bitch. Give it to me. Oh, I shouldn't have to give it to you. You should know where the docs are, is what this person said to me. You should know exactly in the docs where it is if you read them all. I'm like, lay off the meth. You're the one claiming it's in there, bitch. Give me the report number. That's all I need. I just need the ISP or MPD report number for the tip related to Kohberger that they are following up on and substantiating that he is a viable fucking suspect. And I can't get it from anybody. Not even one report number. Not one. So whatever. But Miss Massive here is getting at the same thing that I was getting at. Where are the tips for Mr. Kohberger? All right, let me read through this. Enough of my bullshit. Stop sidebarring, Annie. Stop sidebarring. Okay, so with the exception of information regarding the defendant, none of these tips were substantiated. While it is true that there are thousands of tips, somewhere in the range of 45 to 75,000 tips, and they continue daily, the state has chosen to present evidence of investigations into the specific named individuals and the conclusion that the state has ruled out these possible perpetrators. The state's purported diligence in ruling out possible perpetrators, especially those with close connections to the victims, is an issue that the state is putting front and center at trial in its own case in chief. Mr. Kohberger has the right to confront this evidence. Let's read this again. On page 2 of that motion, the state argued, quote, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. End quote. While it is true that there are thousands of tips, somewhere in the range of 45,000 to 75,000 tips, and they continue daily, the state has chosen to present evidence of investigations into the specific named individuals and the conclusion that the state has ruled out these possible perpetrators. The state's purported diligence in ruling out possible perpetrators, especially those with close connections to the victims, is an issue that the state is putting front and center at trial in its own case in chief. Mr. Kohberger has the right to confront the evidence. So the state is presenting evidence in their own case in chief. No, see, all of these alternate perps, no. The people they're talking about, we already cleared them. We already investigated them. We did our due diligence. We ruled them out as possible perpetrators. And see, here's our evidence of the investigation into those people. Don't worry, Anne, Miss Masseth. You're getting your panties in a bunch over nothing. We already cleared those people. That's what's being said here, right? That's the gist. If I'm wrong, please tell me. But it's my personal opinion based on what I'm reading here, my snarky ass opinion. That's what's being said here. Right? So the state was planning to argue in their case in chief at trial because initially they shouldn't have had to present alternate perpetrator evidence until at trial, right? So when the state is bringing up these witnesses that they allegedly ruled out, this is why the state was putting in evidence and into these alternate perpetrators and how they ruled them out. Air quote, we ruled them out. We did our due diligence. We investigated them. They are not perpetrators, right? If I'm reading that wrong, you can go ahead and leave it in the comment section. I'll try and see it in chat, but I'm pretty sure that's literally what they're saying here. Miss Masseth is saying that the state is the one who put all of this evidence into their own case in chief by using these people not only as witnesses, but also claiming, hey, even though we're using them as witnesses, we also did fucking investigate them at one point, by the way, too. I mean, we did at one point think they were suspects, yes. But we investigated them and we cleared them. Don't worry. Don't worry, Ann. Isn't that fucking wild? Isn't that absolutely wild when you really think about it? This evidence was in their case in chief. They plan to present it at trial. This is wild. The state argues that the evidence submitted in the offer of proof is inadmissible. As explained above, much of it the state seeks to admit in its case in chief. Miss Masseth said, bitch, I took your case in chief and used it as my alt perp evidence. And it doesn't matter whether or not it's direct or circumstantial, motherfucker, because it's your evidence. It's your evidence, and it's in your case in chief. That's fantastic. More importantly, in Chambers v. Mississippi, the United States Supreme Court held that a defendant's constitutional rights to a fair trial and to present a defense sometimes requires admission of evidence of third-person culpability, even in the face of evidence rules that would exclude it. Right. Because due process rights always trump evidentiary rules. Always. There's never an exception. Yeah? Isn't this just... I mean, I don't know about you guys, but each sentence, it just clicks more and more things. Click, 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 click in the brain. Anybody else? It's just click, click, click. Let's read this again. The state argues that the evidence submitted in the offer of proof is inadmissible. As explained above, Your Honor, much of it the state seeks to admit in its case in chief. Meaning, Your Honor, it's their evidence. We took their case in chief and we're using it to show these alt perps that they claim that they investigated and cleared. They actually fucking didn't. That's just my opinion of what they're getting at here. That's just my opinion of what they were going to do had this gone to trial. Just my opinion. More importantly, in Chambers v. Mississippi, the United States Supreme Court held that a defendant's constitutional right to a fair trial and to present a defense sometimes requires the admission of evidence of third-person culpability, even in the face of evidence rules that would exclude it. Hearsay may be admissible in such cases because the Sixth and 14th Amendment rights to due process to confront and cross-examine witnesses and to call witnesses is never precluded. Fairness and trustworthiness of the evidence are important. Mr. Kohberger's proffer includes details that allow this court to see that there is trustworthiness to his basis for naming the 4 alternate perpetrators. Right, Your Honor, because if you're willing to accept this same evidence in the state's case in chief, and you consider the state's case in chief trustworthy, well, guess what? Everything we're using for alt perp came from their case in chief. Right? Right? That's right, Silent G. Due process rights always trump evidentiary rules. Always, always. Your due process rights will never, your due process rights should never be trumped by an evidentiary rule. The right to due process comes first, above anything else, above any evidentiary rule, above any court rule. It's so stupid that they try and pretend like they don't fucking know this as well. But what I'm getting at here is that Hitler, right? According to Hitler, well, the state's case in chief, the state is trustworthy, right? The state's case in chief is trustworthy, right? So if the state's case in chief is trustworthy and the defense is using the state's own case in chief to proffer the evidence of the alternate perpetrators, and the judge is saying it's all inadmissible because it's just circumstantial and rank speculation, well, isn't that fucking interesting? Isn't that interesting? Sir, Hitler, it's their case in chief. What do you mean it's rank speculation? It's their case in chief. We took it from their case. Hitler, right? I, 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 I don't know. That's just what my brain is, you know. What do you mean it's rank speculation, Hitler? It's their case in chief. It's what they plan to present at trial to show that these four alts are people that they investigated because they once deemed them suspects. Everybody's clear on that, right? These four people were at one point suspects, and the state was planning to present evidence of how they investigated them and cleared them in an attempt to thwart the defense from being able to, insinuate they're the alt perps or question them about being alt perps or anything of the sort. It's absolutely wild. Fairness and trustworthiness of the evidence are important, right? That's why we took the state's case in chief. Mr. Kohberger's proffer includes details that allow this court to see that there is trustworthiness to his basis for naming the four alternate perpetrators. And then footnote 1, it says the court cannot consider or weigh the strength of the state's conclusion, air quote, that a suspect has been cleared in deciding if the defendant's evidence is admissible. Let's read that again. The court cannot consider or weigh the strength of the state's, quote, conclusion that a suspect has been cleared in deciding if the defendant's evidence is admissible. Holmes v. South Carolina. Forensic evidence existed, but could still be refuted by third-party perpetrator evidence of a person in the neighborhood. It was reversible error to exclude it. So they're citing Holmes v. South Carolina here. Forensic evidence existed, but it could still be refuted by third-party perpetrator evidence of a person in the neighborhood. It was reversible error to exclude it. So the court found in Holmes v. South Carolina, it was the court's error to exclude, right? To exclude it. Because the court cannot consider or weigh the strength of the state's conclusion that a suspect has been cleared. That's not up to the court, right? That's not up to the court to decide, right? The court shouldn't be considering that. The court shouldn't be taking the state's word for anything that someone was cleared or whatever. The police reports and tips submitted as exhibits in the offer of proof are documents that provide basis to show a link to the case that is more than speculation and grounds that explain the subject of cross-examination or direct examination of witnesses. While the tips themselves may be inadmissible, they are evidence that this court must consider in determining if there is a link and more than mere speculation. Right, Your Honor, because these alt perps are in the tips. Just my opinion. That's what they're getting at here. While the tips themselves may be inadmissible, they are evidence that this court, Hitler, must consider in determining if there is a link in more than mere speculation. Right, because the alt perps are in the tips. When evaluating alternate perpetrator evidence for case link or nexus, some courts demonstrate a willingness to admit purely circumstantial evidence that a third party committed the crime. U.S. v. Stever. Some courts hold that even when the state's evidence is purely circumstantial, the third-party culpability must clearly point to a specific third party, i.e., quote, some act connecting the alternate suspect to the crime, People v. Salazar. In Jones v. Wood, the Ninth Circuit noted that the evidence at Jones's murder trial was primarily circumstantial in nature and concluded that the state trial judge erred in excluding Jones's circumstantial evidence that an alternate suspect committed the crime. Whether direct or circumstantial, all of the alternate perpetrator evidence proffered by Mr. Kohberger has both specificity of person and their connection to the crime. With respect to all of these redacted motherfuckers and how they were cleared and the investigation pertaining to them, that is not a thorough investigation. That is not suspect elimination, as the state argues. Mr. Kohberger did not produce these suspects. The state did. And, in some instances, they continue to investigate them or simply stopped their investigation, ignoring evidence that there was more than one perpetrator. Let's read that again. Mr. Kohberger did not produce these suspects. The state did. And in some instances, the state continues to investigate them. So when was this? June 13th, 2025. Miss Massif is saying the state was still continuing to investigate these alternate perpetrators that they also have listed as witnesses. Let that fucking marinate for a minute, huh? While I have a hot flash. Holy guacamole. I don't wish this on anyone, and I can't wait for it to go away. So isn't that so super, super, super interesting? As of June of this year, just a couple months ago, friends, the state was still continuing to investigate these alternate perpetrators, some of them anyway, even though these alternate perpetrators were the state's witnesses. Some of them are the state's own witnesses. Wild. Let's read this again. Mr. Kohberger did not produce these suspects. The state did, and, in some instances, continues to investigate them, or simply stopped their investigation, ignoring evidence that there was more than one perpetrator. Prosecutor Bill Thompson said he could not rule out two perpetrators from the very beginning. And then here is the link to that. So the prosecutor, Bill Thompson, said he could not rule out two perpetrators from the very beginning. And it was last reviewed on June 6th, 2025, right? So they made sure that they went back and looked at it on June 6th and said, yep, nope, this is what the motherfucker said. Two perpetrators, right? Mr. Kohberger's offer of proof was not an exhaustive list of all of the evidence disclosed in this case that points to the four alternate perpetrators. In fact, the state's opposition disclosed all of this redacted. By listing these alternative perpetrator names on their witness list, and by listing various exhibits on their exhibit list which pertain to these individuals, the state has opened the door for Mr. Kohberger to confront this evidence and cross-examine state witnesses. Remember, we talked a while back, friends, about the opening the door doctrine? Yeah, the opening the door doctrine. Everybody know that? If you are not familiar with the opening the door doctrine, read up on it. So because the state listed these alternative perpetrator names on their witness list, along with the various exhibits that go along to these individuals, that pertain to these individuals, the state opened the door for Mr. Kohberger to confront the evidence and present it as alternate perpetrator evidence. She wasn't kidding in the beginning when she made the comment about we plan to use the state's own case. We have nothing to turn over, actually, because we're just going to use all your shit. We're going to use your own case. I vaguely remember that in the very beginning of all of this. Mr. Kohberger suspects that the state has listed the four alternate suspects as a ruse to make it look as if they will put the four males on the stand to deny their involvement. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but instead uses lab reports to portray elimination, the door is open to confront that evidence, and Mr. Kohberger should be allowed to call the alternate perpetrators and other witnesses to show their connection to the crime. Holy shit. Mr. Kohberger suspects that the state has listed these four alternate suspects as a ruse to give the appearance that they will put the four males on the stand to deny their involvement. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but instead uses lab reports to portray elimination, the door is open to confront that evidence, and Mr. Kohberger should be allowed to call the alternate perpetrators and other witnesses to show their connection to this crime. Interesting. So the state actually decided, it appears here, towards the end, actually, we're not going to call those people as witnesses. We changed our mind. We're just going to show the evidence, just put the evidence, and a ruling excluding or limiting this area of inquiry at this point would be premature. The United States Supreme Court ruling in Chambers allows for the admission of the evidence. The state agrees at a minimum to this confrontation in its objection. This court should allow Mr. Kohberger to present alternate perpetrator evidence. I appreciate all of you being here. I am so very sorry that I'm gonna have to. I think I may. I don't know. Are we back? Are we back? I mean, thank goodness. I think we got through the whole doc. I don't know. Last page or no? Um, I'm not exactly sure what the last part was that you heard. Um, and I have no idea if my audio is. Mic sounds off. Mic check. 1, 2, 1, 2. Yeah, we did have a full-on X class. I know. I know. Mm-hmm. We back? We back? Can you hear me though? Or is it really bad? Where did it cut off on that dock? I'm back. I'm back. I think it's back. I don't know for how long though. Um, that's so weird, huh? So, just curious, what was the last part of it that it was at the end? So did, okay. All right, guys. Listen, love you. Happy Friday. Mods, thank you. Everyone, love you. New subscribers, new members. You guys are awesome. You guys are the real MVPs, okay? Hanging out for even the, hopefully, for now, I'm blaming solar flares and fucking spooks. So, yeah, love you guys. Have a great night. Happy Friday. Stay safe out there, okay? I'll see you around. Bye.